bear in mind. There's also percolating a question of whether a Section 1983 claim could be brought on the basis of Article 36. So much for Sanchez Llamas. Now, Medellin really was the other shoe dropping in the context of the Vienna Convention. And I won't say much more about the self-execution issue, except that it's one of serious consequences for the interpretation of other treaties. People differ as to what the exact effect of the court's language is. Some have suggested that it was more an issue of advocacy on behalf of a result, and that perhaps there was no intention to upset the existing doctrine of self-execution, but it is a very significant ruling, and the language in the court's decision is notable. And they said that one would expect to have the relevant treaties to have clearly stated their intent to give these judgments domestic effect. And similar language which suggests that you're looking at something like a clear statement rule or a presumption against self-enforcement, which, as I think people have said, is not the assumption that people went in with. And my understanding is that the State Department is now engaged in a large march through a number of treaties to determine what the effect of the Medellin decision is on that. The implications for international dispute resolution are, again, as my predecessor said, limited but not insignificant. With respect to individual claims, the Supreme Court was very careful to distinguish the Washington Convention, the New York Convention, so that arbitration awards continue to be enforceable without, I think, any effect of the Medellin decision. The differences in state-to-state dispute resolution, and there, what you see evolving is a framework whereby individual arbitral awards, either an investor state or commercial arbitrations, which have implementing legislation in the U.S. Code, have very strong enforceability in the U.S. system. And state-to-state tribunals awards are generally more likely to be non-self-executing and to require the intervention of a political branch. That, to me, is not so surprising. What's a little more remarkable is that you have the political branch to whom this freedom seems to be delegated trying to comply and being unable to. And I think that's one of the lessons of this decision, which is even if you can trace every step in the legal reasoning, you wind up in a place which seems unfortunate, which is the United States is incapable of complying with an obligation which it wishes to comply with and acknowledges. And you're thrown back basically to Congress to sort of in a case-by-case basis vindicate a treaty right, which I think, regardless of the dispute resolution issue in this case, Article 36 of the Vienna Convention, I don't think there's serious dispute that that provision is self-executing. It is binding of its own force on state law enforcement officials. And at the end of this road, we're left with a situation where there is persistent noncompliance by the states. The federal government wishes to ensure compliance, and we are in the situation where that compliance is not able to be enforced effectively, at least not in the current situation. So obviously the result there is not helpful if you are a treaty negotiator. I can tell you it's hard enough to try and explain our constitutional system to people from civil law systems, post-Soviet systems, who don't understand why Congress has to appropriate something and the executive can't make any commitment whatsoever of anything that treads on congressional prerogative. To try and explain how the United States, has this difficulty in enforcing a federal law obligation can't be helpful in this context. And with that, I'd just like to leave you with one side note. Regardless of where we are in the U.S. legal regime, the decisions in Avena and Legrand, which is a similar case, do have some effect in the general context of international law, which does affect U.S. Companies in particular. For instance, one of the issues in Legrand and Avena, which the Supreme Court left unresolved in its own decisions, is the question of whether an individual has rights under a treaty or whether those rights are derivative of its government. And Legrand squarely decided that under the Vienna Convention, which it did not decide was a human rights treaty, which is important because that strengthens, in a way, the ordinary application of the principle, the ICJ decided that the rights under the Vienna Convention were individual rights. That principle in Legrand was later applied in a case involving Occidental Petroleum versus Ecuador, a bilateral investment treaty arbitration set aside in the courts of England to establish the principle that the American investor had rights as an individual, not derivative of its government, which can be invoked by that individual in the context of international law. So in some ways, the law is a seamless web. I think we're going to hear more about this case, both in the context of international law and obviously in the context of the United States courts. So, thank you.
All right, thank you to all of our panelists. We are a little short on time, but we certainly don't want to leave without allowing you all an opportunity to ask some questions. So we'll start with the first argument up.
On Medellin, none of you have discussed Justice Stevens' concurring opinion, where he saw a kind of states' rights concern here, basically said, we may be powerless at this point, but the states are not in helping the United States fulfill its international legal obligations. He points out that Oklahoma had done so, and he in effect invites Texas to do the same. That interplay between the federal and the state is important in the private international law where I'm interested, and I'd be interested in hearing what your reaction is to that. I know it doesn't satisfy those who'd like to see the federal government have power to force the states, but it is an interesting idea, born in part by his concern that the case is a lot closer than he thought the majorities or the dissent saw it to be.
Thanks. It's an excellent question. I think Catherine did actually allude to
Yes.
Justice Stevens' concurrence briefly. It is an excellent point. It was a hopeful thing that Justice Stevens did, in my view. In my own view, federalism goes both ways, and Article 6 of the Constitution applies here, so that it should not just be a matter of discretion on the part of the judges in Texas. The judges in every state are bound by the treaties made under the authority of the United States, and it is fair for them to conclude that a treaty which has been duly entered in by the United States is federal law and therefore binding upon them. The question still comes back to, what is the remedy? So I think that addresses the legal principle. You do have the unfortunate situation where the presumption is that this is, as Catherine said, a matter of grace rather than a matter of obligation under the framework that has been laid down.
I completely agree as a legal principle. I do think that as a practical matter, particularly in the weeks preceding Mr. Medellin's contemplated execution, that certainly is an avenue that we are exploring. And whether it's a matter of grace or a binding obligation on the legal side, practically, if Texas does step up and say that Texas will be responsible in ensuring the United States complies with its legal obligations, at least for the purposes of Mr. Medellin, that will go a long way.
Yes, sir.
This may be a basic question. I want to return to Boumediene. I've never quite understood why we've had to go through the process of trying to create military commissions over the last few years, as opposed to maybe starting out with the Uniform Code of Military Justice and just trying to high-value detainees from the beginning. I wonder if the speakers could shed some light on what the administration's thinking was. Apparently, not just going down that route.
Administration speakers?
I mean, I'm not an expert in the criminal side of the House, but my understanding is that there is concern that the UCMJ would not provide the proper model and proper protections in light of the security concerns, and some rules had to be changed for that reason. VJ might be more of an expert on this, so I'll defer to him on.
Sure. I think it's a couple of things. I mean, obviously the rules in the UCMJ were designed for trials of our own soldiers, as opposed to trials of alien combatants. So some of the rules that you would imagine using in a trial of our own soldiers are not easily applied in a trial involving an enemy combatant. One example would be hearsay rules, for example. The UCMJ closely